Sometimes, criminal defendants aren't competent enough to participate in a trial. Does that give the state license to hold them indefinitely without proceeding to trial? The Supreme Court answered that question in Jackson v. Indiana. Indiana had 3 statutes governing involuntary confinement in mental health institutions. Each imposed different standards for commitment and release. Committing someone with a mental illness required a finding that the person needed treatment or protection from harming himself or others. Committing someone with an intellectual disability required a finding that the person was unable to care for himself. Committing a criminal defendant required a finding that he couldn't understand the charges and participate in his defense. Once committed, a person with a mental illness or intellectual disability could be released if it served his best interest, even if his condition hadn't improved. Conversely, a committed criminal defendant was entitled to release only if he became competent to stand trial. The state of Indiana charged Theon Jackson with robbery. He was deaf and mute and had a severe intellectual disability. So, the trial court held a hearing to determine his competency to stand trial. Court-appointed psychiatrists testified that even with commitment and treatment in a state facility, Jackson would probably never learn to read or develop the communication skills necessary to understand the charges or aid in his defense. Based on that evidence, the trial court declared Jackson incompetent to stand trial and committed him to a mental institution until such time as he could become competent as required by Indiana's commitment statute for incompetent defendants. Jackson's attorney requested a new hearing, arguing that the commitment violated his 14th Amendment rights to due process and equal protection. The trial court denied the motion, and the Indiana Supreme Court affirmed. Jackson appealed to the United States Supreme Court.